Has Willie pleaded a legally sufficient claim that his 42-year prison sentence shocks the moral sense of the community? Because he has, he is entitled to a chance to prove out the allegations on which his legally sufficient claim is based. If anything, Willie has done more than he needed to do to survive the state's motion to dismiss. He timely filed an initial post-conviction petition, which was later amended, asserting an as-applied challenge to his sentence under Article 1, Section 11 of the Illinois Constitution. And attached to the amended petition is a comprehensive Miller sentencing evaluation relaying Dr. Odamayo's clinical opinions. Those opinions included that Willie's developmental or intellectual age was way below his chronological age of barely 18 years old at the time of his offense. Willie was incapable of understanding the severity of his offense and the consequences of his behavior at the time of his offense. Willie's limited intellectual abilities made him particularly vulnerable to negative peer influences at the time of his offense. Willie's criminal behavior could have been caused by the powerful effects of improperly prescribed psychotropic medications on his developing brain. And Willie has a high potential for rehabilitation with proper medication and increased maturity. Willie does not ask this court to accept as indelibly established fact Dr. Odamayo's evaluation-based clinical opinions about his personal culpability and rehabilitative prospects. But those opinions must be taken as true on second stage review. So at least today, the Miller science applies to Willie's specific facts and circumstances, meaning that at the time of his offense, he had a child's lack of maturity, underdeveloped sense of responsibility, leading to recklessness, impulsivity, and heedless risk-taking. He was more vulnerable to negative influences and outside pressures, including from his family and peers, being unable to extricate himself from the horrific crime-producing setting in which he was raised. And his character was not as well formed as an adult's. His traits were less fixed and his actions less likely to be evidence of irretrievable depravity. These significant gaps that separated the barely 18-year-old Willie from functional adulthood are especially relevant here, where the causal relationship between the criminal actions and the death that resulted is somewhat attenuated. The deceased Mr. Smith was 57 years old, homeless, and had pre-existing health conditions, including cirrhosis of the liver and cardiovascular disease. He died after more than a month in the hospital from multi-system organ failure caused in part by the battery. Recall that the merits of a cognizable proportionate penalties claim are evaluated according to the gravity of the defendant's offense in connection with the severity of the sentence imposed within the context of our community's evolving standard of decency. And the gravity of an offense for purposes of proportionate penalties analysis cannot be judged in a vacuum. Of course, first-degree murder is grave. All murders are grave, but some are far graver than others. It follows that the facts of a murder will justify dismissal of a proportionate penalties claim only where the murder was committed in a particularly grave manner. We can see examples of this in the cases of Hilliard and Thompson, where you have a defendant as the sole perpetrator personally shooting the victim at close range. There's nothing like that here. Willie's participation in a peer-driven, weaponless battery of 5 male victims, 4 of whom walked away with only minor injuries, and 1 of whom died as a result of the battery in combination with his pre-existing health conditions, was not the commission of murder in a particularly grave manner.
Well, counsel, let me ask this. Are we looking at this standard from the perspective of the good people who live in Normal, Illinois? And, you know, can it be argued that a roving gang in a park attacking defenseless people is particularly heinous?
Certainly, it could have been argued, and the state could have made an attempt to establish that the facts of this crime were particularly heinous. But on the limited record that we have on the facts of the offense, which is essentially Willie's plea hearing testimony, he actually gave sworn testimony at the plea hearing for the factual basis describing the offense. No, I don't think that this would qualify as a particularly heinous first-degree murder, looking at the examples that we have in Hilliard and Thompson. We have a very young technical adult who the trial court found his offense was induced or facilitated by his two co-defendants, both of whom were older than Willie. There were other individuals involved in some of the attacks as well who weren't co-defendants in this case. There was substance abuse involved, and then we have all of these factors laid out by Dr. Oda Mayo, telling us that Willie's personal culpability for the choices he made that night is greatly reduced. And culpability is a factor in evaluating the gravity of the offense. So it cannot be justified what was done in the park that night. But we're looking at first-degree murder in this case as compared with the great range of first-degree murders. And by reference to the case law, this certainly wouldn't qualify as so grave as to justify dismissal at the second stage of the proportionate penalties claim. Ultimately, at an evidentiary hearing, certainly the state would have an opportunity to try to bring out whatever additional facts about the offense it felt justified such a severe sentence. But on this record, the gravity of the offense is comparatively limited. And the severity of the sentence is obvious. Willie was sent to prison for 42 years with no eligibility for good time credit. This is a de facto life sentence in Illinois under cases like Buffer, and even this court's own opinion on the appeal of the first stage dismissal of Willie's post-conviction petition. It's more than double the minimum sentence for first-degree murder. And Willie will be 60 years old by the time he's released from prison in the year 2056, if he can even survive incarceration that long. That's an undoubtedly severe sentence. Finally, as to our community's evolving standard of decency, a societal shift towards greater sentencing protection for juvenile defendants is obvious in the law. We have from amendments to the Juvenile Court Act to legislation providing expansive new access to parole review for youthful offenders, including offenders the age of Willie. The trend in positive law is clear. Our criminal justice system has become increasingly cognizant of and responsive to the differences between juvenile offenders and adult offenders. And again, because we must take as true Dr. Oda Mayo's conclusion that Willie was akin to a juvenile when he offended, this societal shift toward greater sentencing protection for juvenile defendants does tend to advance Willie's proportionate penalties claim. And that's really the end of the analysis of the merits of this claim. At the second stage, we looked at gravity, we looked at severity, and we looked at our community's evolving standard of decency. The substantial showing was made. Willie timely filed his initial post-conviction petition, raising a cognizable claim that his 42-year prison sentence violates Article 1, Section 11, because Judge Jaszewski failed to set the sentence according to the seriousness of the offense and with the objective of restoring him to useful citizenship.
Counsel, let me ask a question. What would you have expected the trial judge to do if he had balanced the factors in the way that you are arguing? I know that's speculation, but I'm interested.
With respect, Justice Connacht, it's not about something that the trial court failed to do. That's more of a procedural claim. We know now that an emerging adult offender who received a discretionary life sentence or de facto life sentence cannot raise that procedural claim and say that.
Yeah, I didn't ask that question very well. I did not mean that there was a procedural defect. This was a matter for the trial court to evaluate. how should he have better evaluated and thereby given a lesser sentence?
Again, with respect, I don't think it was the process of evaluation that was deficient. It's the actual result. It's the sentence that the court arrived at that cannot be justified by reference to this particular defendant's personal culpability, by this particular offense's gravity, and by the severity of the sentence imposed.
So we're really back to the notion of whether or not this would shock the conscience of the community.
Yes, the standard is whether, please, whether this sentence shocks the moral sense of the community. Yes.
Do you think if the community knew about all of the bad choices as well as the bad influences on this young man and everything that he did leading up to this, the choices that he made freely, but at the same time, likely true under the influence of others, that the community would be shocked that the trial court would give this kind of a sentence to this brutal beating of a homeless man, coupled with a roaming group of young men trying to do it to other people and simply stopping before there was such a tragic result as to those others. Do you think that the community would be shocked by a 42-year sentence?
I think a community that was educated in the Miller science that applies to this defendant, making him like a child at the time that he made these choices, would be shocked to treat a child in this way who had limited ability to resist the negative influences that were on him. The clinical neglect that he received from the services of the state of Illinois, misdiagnosing him, mismedicating him in a way that probably affected his brain as a child. Certainly, the public will be shocked and appalled by crime when they hear of it, but the public isn't positioned to know all of the intimate details of the law as it's developed, the science as it's developed, and of this individual person who was like a child when he made these very poor choices.
Well, if he's like a child, did he even deserve 20 years, which would have been the minimum sentence? That's all the judge could have done to address your argument. Is that true?
I believe that the judge could have imposed a constitutional sentence within the statutory range. However, Willie could have raised a proportionate penalties claim even against a 20-year sentence. I think it would have had less merit than the claim that he asserted against his 42-year sentence. I also think that while the merits of this claim can be debated fairly, this is really a question for the third stage. Willie has produced evidence that he was like a juvenile and how that played out in his particular case. That evidence has to be credited at the second stage. The time to parse the evidence, to question its credibility, to maybe decide that it's not sufficiently individualized to Willie, it's more of a generally applicable to all very young 18-year-old men who came from chaotic and traumatic backgrounds. The time for those arguments and analysis is the third stage. And Masters, this court's opinion in Masters, really shows what that might look like when you get to the third stage with this kind of evidence from a clinician regarding the defendant that doesn't have to be credited at the third stage, but the time hasn't come for that level of analysis. Right now, all we're looking at is whether Willie pleaded a legally sufficient claim and produced enough documentation to survive second stage review. And he has done that. When the third stage comes, then those questions will definitely be relevant for initially the trial judge and anyone else who may need to look at it after that.
Ms. Kemp, I want to follow up on your answer to the question that Justice Connect asked about the community. And your answer was that, and I'm just going to summarize it, that a community that was educated in the science that you've argued here would find the sentence shocking. But is that the standard? Is an educated community, or is the standard that we take the community as they exist today, and whether they're educated or not educated on that topic?
So when Hilliard articulates the standard of, and I want to go to the quote to get it absolutely correct, our community's evolving standard of decency, it doesn't expound on whether by that it means, the public at large or the community of Illinois, the people of Illinois in a general sense. And I take our community to be a reference to everybody as reflected in legislation. Our legislature acts on behalf of the people because people aren't positioned to understand all of the nuances that the legislature is. And so our legislature has access to the relevant considerations and has spoken for the community by making these sweeping legislative changes, indicating recognition that juvenile offenders are to be treated differently from adult offenders. And Willie gets scooped into that category of juvenile offenders for purposes of this evolving standard of decency because of Dr. Odamayo's conclusions.
Thank you.
This court has an opportunity today to clear some confusion on the current status of emerging adult proportionate penalties claims by holding that Willie is entitled to an evidentiary hearing at which he may seek to prove his well-pled allegations regarding the particulars of his offense, his individual characteristics, and our community's evolving standard of decency. And this court should take that opportunity. Willie respectfully requests that this court reverse the dismissal of his amended post-conviction petition and remand for an evidentiary hearing on his legally sufficient proportionate penalties claims.
Thank you, counsel.
Thank you.
We'll hear from you on rebuttal. Mr. Hulbert?
Yes, good morning, Your Honors, counsel, and may it please the court. My name is Jacob Hulbert, and I'm here on behalf of the people. Even though counsel has not addressed it here today, I'd like to start by addressing defendant's waiver of his proportionate penalties claim by entering into a negotiated plea that precluded the people from arguing for the full range of available penalties. And then, of course, I'll proceed to address the substantive claim. As to waiver, defendant's proportionate penalties claim is waived because he received a material sentencing concession in exchange for his guilty plea and was ultimately sentenced within the range determined by that plea bargain. Defendant pled guilty to first-degree murder in exchange for several concessions, and most important to waiver, the people's agreement not to seek a finding that the murder was accompanied by exceptionally brutal or heinous behavior. That concession mattered because such a finding would have authorized a sentence up to natural life in prison. Instead, defendant's plea limited his sentencing exposure to the ordinary 20 to 60-year range for first-degree murder. And under Diaz, that is a sentencing concession because the people agreed not to seek extended term sentencing, which in turn restricted the punishment the people could seek. Before the agreement, the people remained free to take the procedural step necessary under Section 111-3C5 to pursue a wanton cruelty finding and the greater punishment that could follow. And defendant even concedes here today that the state could have sought that finding. And as part of that plea bargain, the people surrendered that course of action entirely. That was a concrete benefit to the defendant because it eliminated his exposure to enhanced punishment. Despite predating Apprendi, Payne illustrates the principle that the people's agreement to forego more severe punishment constitutes a sentencing component of a negotiated plea. And this court's decision in Williams reinforces the contractual consequences of such a bargain. A defendant may not retain the people's concessions while treating the sentencing component of the agreement as though it never existed. Instead, Williams applied that principle even where Williams applied that principle even where the purported extended sentence was ultimately not legally available. And here, by contrast, the state was capable of pursuing a wanton cruelty finding, but agreed not to take those steps. So on these facts, the sentencing benefit defendant received is even more concrete than the one in Williams. Defendant attempts to avoid that conclusion by characterizing the wanton cruelty provision as a charging concession or separate offense under Carwell, but Carwell is materially different. In Carwell, the people actually amended the murder count itself. The original count alleged that the defendant shot the victim, and as part of that plea, the people amended the count to say that the defendant rather struck the victim, while also dismissing murder counts containing the firearm enhancement elements. And as a result of that, it was clear that the people altered the charge to which the defendant pled guilty by amending the very language and thereby making a charging concession. That did not occur here, though, as the people in no way amended the charge that the defendant pled guilty to, but instead agreed not to pursue an aggregating factual finding that could increase the punishment. So Carwell involved an actual amendment to the substantive charge, which in effect reduced the charge to a lesser offense. And by contrast, here, there was no corresponding amendment to the charge as defendant pled guilty to the same first-degree murder charge alleged in the indictment. Nor would there be any need to amend the charge here because all that was necessary to seek an extended term sentence was notice. The only thing that changed here because of the plea was the punishment the people could pursue. However, defendant does argue that natural life was not available on the guilty plea because extended term sentence had not been alleged, but the people were not legally disabled from pursuing that wanton cruelty finding as counsel acknowledged here today because section 111-3 permitted the people to just provide notice and seek that finding an extended term sentence. The entire point of the bargain and an express agreement of the bargain was that the people promised not to take those additional steps if defendant pled guilty. Had defendant rejected the plea, the people would have provided the required notice, sought a wanton cruelty finding, and if successful, argued for natural life. By accepting the plea, defendant took that available sentencing range off the table. That is a real limitation on the punishment the people could seek, and in turn, a sentencing concession, which results in the waiver of defendant's substantive claim. However, even if this court does not find that defendant waived his proportionate penalties claim, the circuit court properly dismissed that claim at the second stage. Even accepting defendant's allegations and Dr. Odamayo's conclusions as true, defendant has not made a substantial showing that his 42-year sentence is cruel, degrading, or so wholly disproportionate to his offense as to shock the moral sense of the community. That is the constitutional inquiry that should guide this court's analysis. Defendant's brief focuses heavily on the considerations associated with Miller, such as his youth, developmental immaturity, susceptibility to peer influence, impaired judgment, intellectual limitations, and rehabilitative potential. And while those circumstances are certainly relevant, Hilliard and Thompson instruct that those considerations themselves do not establish a proportionate penalties violation. Although the developmental science underlying Miller may inform that analysis, the question remains whether this particular punishment imposed on this for this particular offense and on this particular defendant is so wholly disproportionate as to shock the moral sense of the community. And in this case, it just simply doesn't. First, the gravity of the offense was extraordinary. This was not a spontaneous confrontation or a single impulsive act that unexpectedly resulted in death. Defendant ignores that he and his co-defendants were participating in a game that they called point 'em out, knock 'em out. And the premise of that game is exactly what its name suggests. They selected random strangers and attacked them for their own entertainment. And 5 people were attacked that evening. The murder victim, a 57-year-old homeless man, was lying beneath a tree when defendant and his co-defendants randomly selected him as one of their victims. The group attacked the victim a first time, with the defendant throwing the first punch to the victim's face, followed by his co-defendants joining in. But the violence didn't end there. After the first attack, defendant and his co-defendants retreated and later saw the victim attempting to leave. Defendant and his co-defendants again, unprompted, ran up to the victim, attacked him a second time. And before defendant ran away the second time, he apologized to the victim, which explicitly demonstrates that defendant understood the criminality of his conduct at that time. And DNA evidence further revealed the presence of the victim's blood on the defendant's shoes. So it's not like he was a mere bystander in this incident. And ultimately, the victim died as a result of those injuries that he sustained. The sentencing court itself recognized the extraordinary gravity of that conduct, observing that the offense was the type of conduct that would shock the community. That finding reflects an important part in the proportionality analysis because the punishment must be measured not only against the defendant's mitigating characteristics, but also against the profoundly senseless, callous nature of the offense itself. Defendant attempts to lessen the gravity of the offense by emphasizing that no weapon was used, that several other victims suffered only minor injuries, and that the murder victim suffered from underlying medical complications. But those circumstances do not materially alter the fact that the murder victim had done nothing to defendant, but rather was randomly selected, attacked a first time, attempted to leave, and was attacked again, resulting in its death, all part of a big game for the defendant. The absence of a firearm also does not make that conduct constitutionally ordinary. And the fact that the defendant may have not anticipated the precise physiological mechanism of the victim's death does not erase the gravity of the repeated violence that produced it. And second, the sentencing record demonstrates that defendant's diminished culpability was not ignored and instead reflects a sentence that comports with mitigation defendant relied on then and relies on now. The trial court recognized that defendant's conduct was influenced and facilitated, at least in part, by others and further recognized the role peer influence played in this offense. The court also found that drugs and alcohol somewhat contributed to the conduct and observed that defendant's prior offenses had not been caused or precipitated by those same circumstances. And more broadly, the court was aware of the defendant's youth, intellectual limitations, immaturity, poor judgment, behavioral control problems, susceptibility to negative peer influence, and rehabilitative potential. So in other words, the sentencing court did not treat defendant as though he possessed the judgment, independence, or culpability of a fully mature adult, unaffected by outside influence, but rather expressly recognized defendant's diminished culpability. That is important not because the mere consideration automatically defeats the defendant's claim here, but because the resulting sentence reflects a balancing of defendant's reduced culpability against the seriousness of his conduct. And that is evident by the sentence that the court handed down, which rejected the people's request for 60 years after recognizing that substantial mitigation and defendant's diminished culpability played a role and ultimately sentenced the defendant to 42 years, 18 years below the maximum. So the sentence imposed is not one that ignored defendant's youth-related limitations. It is a sentence that already reflects them while also accounting for the seriousness of the offense. And additionally, defendant's youth and developmental limitations must be viewed in the context of his history. Prior to the instant offense, defendant accumulated a significant juvenile history and a criminal conviction for residential burglary that he was serving a term of probation for when he committed this offense. While that does not eliminate the mitigating force of his youth, it does matter when evaluating the culpability and proportionality. It shows that defendant participated in an escalating course of random violence while already on probation. That history also gives context to the sentencing court's finding regarding the role of drugs, alcohol, and peer influence. The court simply did not assume that the defendant acted with full maturity, but instead acknowledged that the offense was influenced by other factors. But even still, defendant voluntarily participated in repeated attacks on random strangers as part of a game, including the 2 attacks on the murder victim. Now, the The crux of defendant's argument relies on Dr. Odimeo's post-conviction evaluation, which concluded that defendant's developmental and intellectual age was way below his chronological age, that he was susceptible to peer influence, and was previously misdiagnosed and improperly treated. And even assuming all of that is true, and in large part the sentencing court considered the same aside from the misdiagnosis and mistreatment, but still, assuming all of that is true, those limitations do not fundamentally alter the landscape of defendant's diminished culpability demonstrated at sentencing. And more importantly, they do not demonstrate that defendant's 42-year sentence is shocking to the moral sense of the community based on his active participation in a series of random assaults and repeated beating of the murder victim that was all just a big game to him. Dr. Odimeo's conclusion that defendant has matured and possesses substantial rehabilitative potential also does not change that calculus. While rehabilitation does matter, it does not override the seriousness of the offense. And even defendant's own post-conviction materials complicate the weight he places on his present maturity. When describing the offense, when describing the offense to Dr. Odimeo, defendant described the attack on the murder victim in a justificatory manner by describing the victim as an older man who was behaving sexually inappropriate towards teenage girls and suggested that the victim's beating occurred in response to that conduct. That account differs drastically from the testimony defendant gave at the plea bargain hearing, but the state is not asking this court to resolve the discrepancy as a credibility question or reject Dr. Odimeo's conclusions regarding rehabilitation. The state only brings that up to point out that defendant's materials do not reflect an unequivocal acceptance of responsibility for the conduct underlying his sentence. And finally, with regard to Robinson, defendant's reliance on Robinson does not compel a third stage evidentiary hearing. In Robinson, the post-conviction evidence materially altered the mitigating picture that had been before the sentencing court. The information available at sentencing portrayed a relatively normal developmental and psychological history compared to the post-conviction evaluation. The new evidence introduced aspects of trauma, familial dysfunction, and gang affiliation, none of which were introduced before the sentencing court. That is not what occurred here. Here, the sentencing court already knew that defendant was unusually immature, intellectually limited, susceptible to peer pressure, impaired in his judgment and behavioral control, and capable of rehabilitation. More importantly, the sentence here and the sentencing court's findings reflect that defendant's diminished culpability were factored into the sentencing calculus. The court found that defendant's conduct was influenced or facilitated to some extent by others. It recognized the role of drugs and alcohol, distinguished this offense from his prior offense, and received evidence of rehabilitative potential, all which mitigated the imposition of the maximum sentence. While Dr. Odimeo's report adds clinical detail and scientific explanation for defendant's limitations, unlike Robinson, it does not reveal an entirely different offender or expose fundamentally inaccurate mitigating pictures at the original sentencing hearing. Dr. Odimeo's evaluation differs in the sense that it found defendant was misdiagnosed and mistreated and has since matured and possesses substantial rehabilitative potential. But even still, the fact remains that defendant actively participated in a game centered on assaulting random strangers. That game resulted in multiple beatings of the murder victim, who did absolutely nothing to prompt the attacks and was ultimately killed. Defendant's 42-year sentence expressly accounts for the severity of that conduct, while accounting for defendant's diminished culpability and rehabilitative potential, and as a result, the defendant has failed to make a substantial showing that this sentence shocks the moral sense of the community, and this court should affirm the second stage dismissal of this petition. And I'd be happy to take any of your honors questions if you have any.
I see no questions, counsel. Thank you for your argument.
Thank
Ms.
you, your
Kemp?
honors.
Rebuttal.
Thank you. I have to make 3 quick points on rebuttal. First, as to the state's argument of waiver by plea agreement. It ignores Apprendi, Apprendi counsels that facts that expose a defendant to a punishment greater than that otherwise legally prescribed are, by definition, elements of a separate legal offense. So by agreeing not to pursue a finding of wanton cruelty, the state agreed not to pursue a separate legal offense, altering the charge to which Willie pleaded guilty. Under Apprendi, this was a sentencing concession. Diaz also assists here. Under Diaz, a sentencing concession is a term of a plea agreement that, quote, limits or forecloses the state from arguing for a sentence from the full range of penalties available under law. And here, enhanced sentencing was not available under law for the offense to which Willie pleaded guilty. The state could have tried to pursue that offense, which would have been a charging decision. Its agreement not to pursue that offense was thus a charging concession. If anything, this is stronger than Carwell because there the state altered the charge, and here the state agreed not to alter the charge. It's just kind of the flip side of the charging concession. Most of the state's arguments as to the merits would be perfectly at home were we here on a third stage denial of post-conviction relief, but we aren't. We're here on a second stage dismissal of the post-conviction claim. And it's a crucial distinction because the question before this court is not whether Willie's sentence shocks the moral sense of the community. The question before this court is whether Willie has pleaded a legally sufficient claim that his sentence shocks the moral sense of the community. And that's a distinction with a difference. Pleading is sufficient. The supporting documentation is sufficient. Let it go to an evidentiary hearing where these arguments can be made, Dr. Otamayo's conclusions can be tested, and the trial court can make a decision. Third, there is new information here that wasn't available at sentencing. Dr. Otamayo twice interviewed Willie years after the crime, some 8 years after. That allowed her to compare the man that he is now in his later 20s to the documentation of the offense. And she could do that against the backdrop of the science that has evolved in the years since the offense, against the case law that has developed over the years as well. She had Willie's DOC, behavioral disciplinary records, which were not available to the trial court, showing how he's matured out of the violent behavior of his earlier youth. And she could recognize his real progress and maturation and rehabilitation. The trial court couldn't do any of that because he was faced with essentially the same barely technical adult who had committed the offenses. The state attempts to distinguish Robinson on the basis that the information from the post-conviction petition was different from the information that the sentencing court had. But there, in fact, the information from the post-conviction petition was different from, not just additional to, but actually contradicted in many ways the sentencing court's information. So again, here, the evidence that Willie has attached to his post-conviction petition is stronger because it's fully consistent with what the court had at sentencing and all the records going back to his very early childhood. It just builds upon them. It provides more, and it provides a look at who Willie has become over time. So Robinson is useful to this court in seeing an example of substantial showing at the second stage. This case is stronger than Robinson, not weaker. And Willie respectfully requests that this court reverse the dismissal and give him his third stage hearing. Thank you.
Thank you, counsel, and thank both of you for your arguments. We'll take this matter under advisement and await the readiness of the next case.
Council's out of the meeting and the live stream is ended.